Minister, I think my view on the bill is that it's unpalatable but necessary. Home ownership, as we know, is particularly strong in Ireland, and it's something we should be proud of. The figures are quite interesting. Our repossession rate in Ireland is 0.25%, as opposed to figures we heard from the Secretary-General of Finance saying that in the UK it's 3%, in the US up to 4 or 5%. So our low rate of repossessions, notwithstanding the recent lacuna, is something we should be proud of. And unfortunately, I recognise, Minister, in this bill that if lenders can't call on the security against a loan, then it's going to do some very bad things ultimately for the citizens, as the price of those loans would go through the roof. So for me, the task before us is to ensure that whilst the lacuna in the law is fixed and that repossessions are brought back in, that they are always a last port of call, and that the process of repossession is as compassionate as possible and as understanding as possible, and that it protects the borrower, because obviously we have this huge asymmetry in power between a bank coming in armed with lawyers, accountants, going in and negotiating with usually very, very distressed borrowers, parents, individuals. So there's a huge imbalance of power, and I think we need to do everything we can within this bill to make sure that that is rebalanced insofar as possible. Minister, I would like to recognise something that is very welcome in this bill, which is that you've given judges the discretion to refer a borrower and a lender to a personal insolvency arrangement rather than go through possession. I think that's a very welcome change, and I thank you for including that. And I would like to cover 6 issues. I think there's 6 additional opportunities here, and I'd like to propose solutions against 5 of those. One of them, I'm afraid, you're going to have to work out yourself. I don't know what the answer is. The first of these is to do with the veto that the banks have under the personal insolvency arrangements. As you know, Minister, I don't believe the banks should have been given a veto, but they have a veto. And my sense is that it could be abused here in a repossession. So if we play it out, a bank moves to repossess a home. It goes before the judge. The judge says, look, you know, I'm not comfortable with this. I think an arrangement can be reached via a PIA. So they direct the bank and the borrower to go to a PIA. The bank can essentially say, fine, we'll do what the judge says. We're going to apply a veto. It doesn't really matter what the PIP comes back with, what the borrower comes back with. We have a veto, so yes, we will comply with your order, but we'll be back here and, you know, we're going to apply our veto. So I think there is a danger here that the veto could be abused. So what I would ask you to take a look at, Minister, is when it comes back before the judge, let's say it goes through and the bank issues a veto, that the judge can take evidence from the PIP. I mean, ideally from the borrower as well, but if we recognise the PIP as an independent expert third party, and that should the PIP say to the judge, look, the bank is not cooperating with the PIA. They've exercised their veto, but we have actually put a structure together which this bank or other banks have accepted in different cases. And it is my expert view as the PIP that actually I don't think the bank is cooperating with the spirit of the legislation. That in that case, it would be very useful for the judge to be able to order further adjournments or to keep instructing the bank to go back. And as long as the PIP was not satisfied that the bank was cooperating, recognising that there may be a repossession at the end, that the judge could continue to direct cooperation in a PIP. I think that would be very useful. I think it would be very useful for the judge to know whether or not the lender has cooperated, whether or not the lender has turned down reasonable offers, and whether or not the lender has turned down offers which this lender or other lenders have accepted in other cases. I think that would be very useful evidence-based opinion. The second issue is around how the bank behaves during the code of conduct, during the MARP process, and whether or not it has adhered to the CCMA. My reading of the proposed legislation is that the bank's conduct within the CCMA, within the MARP, and whether or not it has adhered to the Code of Conduct and Mortgage Arrears, is inadmissible in repossession proceedings. It doesn't matter. We'd all like the bank to have adhered, but it's a voluntary code, and ultimately the bank can say, look, I'm enforcing the security, I'm enforcing the contract, I'm taking the house. Now, we know that there are pretty onerous stipulations put on the borrower to cooperate with the code of conduct on mortgage arrears, or rather on the mortgage resolution process, and that a bank, if it deems a borrower to be non-cooperating, can designate a borrower as such, and that there is a chance that therefore the borrower will not actually have access to personal insolvency legislation. I would like to see a situation where the bank's behaviour up to the repossession hearing can be taken into account by the judge, Minister. And Noeline Blackwell of FLAC, you may have heard recently, suggested that the central bank code of conduct should be put into a statutory instrument. And if we could find a way whereby, in a repossession hearing, if a lender, if a bank has clearly not cooperated in the spirit of what you, Minister, and the government intend, then that could have some substantive influence on proceedings. I think that would be very, very welcome. The third issue, I hope, is just a technical one. In the bill it says that the judge can grant 2 months for borrowers and lenders to reach an agreement under the PIA. The guidelines given in the Insolvency Service talk about 70 days. So when you read through what a PIP has to do in order to engage with and set up a PIA, it says they have to review the case, including the financial statements. They have to submit an application for the protective certificate to the Insolvency Service, and then they have 70 days to develop a proposal, get it voted on by the creditors, and have it submitted to the court for assessment. They have to ensure, obviously, 65% of the creditors are okay, and they have to do various other things like record the meetings. So the Insolvency Service itself is saying, look, the PIP needs 70 days. And this bill says 2 months. So I'm hoping this is just a technical timing issue, and what I would like to see maybe is if the PIP could be given, let's say, 3 or 4 months rather than the 60 days. I guess 60 days is 2 months. If that could be extended from 2 months to 4 months, I think that would provide some much needed time. So hopefully there could be some consideration of that. The fourth issue is a difficult one, and it's to do with cost. So if we go back to the court, we have a family or an individual having their home repossessed. They clearly have no money or insufficient money to pay their mortgage, or even a restructured version of the mortgage, hence the repossession. And the judge can say, look, you've got to go and do a personal insolvency arrangement. Go and find yourselves an insolvency practitioner and have that practitioner put a PIA together with your lender or lenders. The family or individual have no money, or certainly they have no spare cash. Now, we're hearing that, I mean, the market is obviously going to decide how much the PIPs cost. But we're hearing figures of 5,000, 6,000, 7,000. And there's no direction as to who has to pay for that. So we could very conceivably have a situation whereby the borrower or borrowers go back out, they try and find a PIP, and the bank says, well, I'm not paying. You know, maybe it can be part of the restructure, but I'm under no obligation to pay for this, let's say 5, 6, 7,000 euro. And the PIPs, looking at the borrower, say, well, you've got no money to pay either, and I, the PIP, am not convinced that you're going to get any restructured arrangement where I can get my money out. I think we could find ourselves in a situation very quickly whereby no PIP will do the work. Or, if we think about the market, maybe you'll get 1 or 2 PIPs who can't get work anywhere else, who will do it for less money, or who will do it on the basis of an agreement. But the market being what it is, you're probably not going to get the best service out there. So, Minister, what I'd like you to consider is, in the case where a judge directs the lender and the borrower to engage in a PIA, that some other source of funding is found. I would like it to be the bank, obviously. Maybe it could be done through some of the civic society groups, like New Beginning, for example, or maybe it could be done through MABs. I don't know. I know they're doing the debt relief notices. Not convinced they're going to be doing the PIAs, but some method, I think, should be found whereby the bank or the government, through service providers in the community, can provide this to the borrower. So, Minister, if you might look at that before committee stage and consider bringing an amendment to ensure that the lack of ability to pay doesn't essentially exclude very, very distressed borrowers from the insolvency arrangement. I think that would be very welcome. The fifth issue, Minister, is the one I don't have a solution on. It's a complicated one, and it's where a buy-to-let and a family home are connected. And actually the repossession is coming about not because of the family home, but because of the buy-to-let. So it's a pretty standard case, family home, there is enough income coming in to pay the mortgage may be 10, 15 years into payment. They made an investment like so many people for a pension or whatever, they bought a single apartment, that has collapsed in value, in rental yield, whatever. And as a result of that, the bank is saying, look, we're moving for possession of your buy-to-let property, but actually it's in negative equity, so we're also moving for possession of your home, which from a financial perspective kind of makes sense, right? They have security in the home, they have security in the buy-to-let, but it's a very perverse outcome that someone would have a solid home which they can afford to pay for and continue paying the mortgage on. Yes, there was an investment that went wrong, but as a result they lose both. As I say, I don't know what the solution to this is. It's tricky, but I would very much like you and your officials to, and I imagine the committee, to just have a think about, is there some way we can stop this happening? And we have an analogy, I think, in the private sector whereby viable businesses in towns all around the country bought one or maybe two investment properties. Those investment properties have tanked. And actually, businesses may end up getting shut down as a result. Now, I think there's probably reasonably broad agreement in the House. You don't want to shut down viable businesses because they made one or two failed investment decisions on property, and you're trying to ring-fence the viable business. So you might just...
used in excess of 10 minutes of your time, but you could have had a 20-minute slot, but I think you gave an indication you're going to take 10, so do you wish to proceed for...
I'll finish right now. Yeah, sorry, I thought you were going to tell me when I had 2 minutes left.
Yeah, well,
I'm on the last one now.
No, go for 2 minutes.
Fine, cool.
Yes,
no, I'm good. Thank you,
Yeah,
I appreciate it.
Yeah.
Right. Yeah. Appreciate it, thank you. So anyway, I don't know what the answer to that is, but I would hate to see a situation where people lose their homes over buying an apartment in 2005.
The next speaker's Tom.
And then finally, it's not connected to the legislation, but I think it would come in with the legislation, is funding on the borrower side for representation. So there's a range of organisations out there, the Insolvency Service, MABS, FLAC, Customer Information, New Beginning, etc., who need representation. So if the process has moved to the point where the bank is looking to take possession of the house, it's moved to a pretty bad stage. And we regularly see, and I see it in my office in Wicklow, I'm sure you see it, Minister, in yours, we see a situation where the bank is negotiating with all the powers and all the expertise of the bank with a couple who have nothing, they're stressed out of their minds, and they have no representation. They've no one to go into the bank with them, they've no one to negotiate with them, they've no one to go into court with them, and they're just, you know, they're fed to the wolves as far as I can see. I don't think that's something any of us would like. And what I would like you to consider, Minister, I guess in conjunction with this, or maybe it could be baked into the bill, I don't know, is to ensure that any individual or couple who are going through a repossession situation do have the kind of professional, legal and financial representation that the likes of New Beginning provide. So that's it, there's the issues. I'm more than happy to submit them to you, write them down, Minister, and send them to you in a letter, and maybe we could pick them up at committee stage. That's it, thank you very much.
Yeah. Thank you, Deputy.